Good evening, chat. How are you guys doing tonight? Um, my eyes hurt from me in the computer sometimes. That sounds like it sucks. Maddie. Oh, womp womp womp. Womp 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 womp. Sorry, buddy. Sorry out there. Anyways, good evening, everybody. Welcome. It is Wednesday night, and we are going to be talking about the story of Adnan Syed. If you guys are new, my name is Sean, also known as Potentially Criminal. I am a defense attorney in the Cleveland, Ohio area, and obviously talk about criminal defense stuff mainly. And this is going to be one of those nights. And this is the night where you've heard me talk about these issues before about victims' rights, but this gets into policy considerations, things that haven't been done that probably do need to be done, problems that have been addressed that the court system has to address, and they didn't really take advantage of addressing them. That's ultimately the issue here. This is victim rights run amok. And I think that's the best way to describe it, because it really is victims' rights run amok. Of course, when the idea of victims' rights came out, that victims have these legally protected rights because they felt like they were getting treated poorly in a courtroom. Sure, of course, these rights passed everywhere they happened. Do you want to be part of the victims' rights bills? Sure. Do you want to oppose the victims' rights bill? If you're in, whatever legislature you're in, that's never going to happen. That's like a free puppy bill. You're never going to say, no, I think that, for whatever reason you might oppose it, all people are going to hear is that you opposed a bill giving everybody a free puppy. So in this situation, you're going to be known as the guy who opposed victims' rights. Not that, oh my God, this is a train wreck for the 6th Amendment. This violates multiple constitutional issues. A victim doesn't have the right to interfere in a case like this. Because in multiple states, they've had those problems where things got to be a pain in the ass. But no, otherwise, you're just against victims' rights. And that's the problem there. And that's where we're going to start. The basic issue here is the prosecutors in Adnan Syed's case initially convicted him in 1999 and sentenced him to life in prison. Now they don't think he committed the crime. Whether or not you think he did or didn't, doesn't really matter. The prosecution says, we don't think he committed the crime. We want to vacate his sentence. Obviously, the defense on the other side is going to say, hell yeah, sounds great. But in Maryland, the victims get to come in and say, we have our own due process rights. We have a right to talk and be heard and give our input. Okay. But your input's not controlling. And that's where we are right now, is how did the Maryland Supreme Court deal with that issue? And based on, if you guys can read the title and the thumbnail, obviously probably not a way I think is appropriate. So we're going to get to it. And like I said, guys, you may think Adnan Syed did murder his girlfriend. He did commit the murder. Cool. That's not the issue for tonight. Okay? That's not the issue. I mean, the real issue is, do the victims get to be involved like that? Do the victims and their families get to interfere the way they do this? And I don't think this is the right answer. It shouldn't be the answer. But for now, that's the problem. That's the problem we face. And that's the problem we're going to tackle tonight. And before we get started, if you guys don't know, Adnan Syed and Hae Min Lee were boyfriend-girlfriend. They were in a relationship. And this is them. Obviously, Hae Min Lee she's dead, so we don't have a new picture of her. But that's her. This is Adnan Syed. And this is them back when they were in high school and back when they were kids. And I think that just so you understand who you're looking at, who you're talking about, just give you a bit idea. And real quick, we're going to get started here. Benjamin Lewis says, is Tim Pool a victim or defendant in the new DOJ filings? He's listed in them for right now. I'm going to cover that tomorrow because I need to read through that. And oh boy, some people better be like, if I was Tim, I'd be getting a fucking lawyer right now because this doesn't look good. All right, let's see where you guys at here. Porcelain does saying if it's Maryland, it's the wrong answer. Yeah. And Chinny and I saw you and Kat saying, did I get my hair did? Yes. Got my hair cut today. It seems. Yes, apparently Tenet Media. And just so you guys know, they are a conservative group. And if we're just going to cover this real quick since you guys are asking. So there's a big DOJ indictment that got dropped. So like they got Dave Rubin, Lauren Southern, Benny Johnson, Tim Pool, Matt Christensen, and then I don't know who the hell this guy is. They were this company was funded by Russian money. Lauren Chen helped set it up. So the two Russians that were funneling money in are getting indicted. I bet Lauren Chen will probably get indicted very soon. And from there, who knows? But I think Tim Pool and Dave Rubin are very, 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 very much they should be getting attorneys. So we'll cover that tomorrow night. A lot to talk about. The indictment says they hid who they were affiliated with for now. Like I said, there's still there are a lot of issues to unwrap in that. There are a lot of issues to unwrap. Anyways, let's get on to Adnan Syed and what happened with him. So we have the beginning of this, and this is how in its style, the styling of the case. This is the way the Maryland Supreme Court does it. They have all this garbage at the top. And then we get to the Supreme Court of Maryland. In the September term, you have Adnan Syed versus Young Lee as victim's representative et al. And there were judges who did this. They have a couple different they list all the judges that were there. They did the opinion. The opinion was done by these judges. There was a dissent as well. And they point out one of the judges participated as an active member of the court. And after her retirement, she was called back to come take care of the decision, which that's a pretty cool way of handling it. That is an interesting way of handling it. So we are going to skip a bunch of this preamble here because there's a bunch of this that, the background of victims, crime victims' rights. This is really interesting to read if you want to read about it. There's not really how things were done. But yes, in England, it was traditional for a victim to organize a crime patrol to track down somebody and pay restitution. I mean, that was like you could to set up a crime patrol, that's a very funny way of saying you and your buddies got together and formed a posse and went to go fucking hunt down the guy who fucked your buddy over. So it's I like how they phrase it, but it's really like, let's not lie about what it was. They talk about more in colonial America, private prosecutions were more common and you could sue people. There was an increased ability to bring suit. But we're going to get to actually like what happened in this case because there's a lot to start with there. In this case, we need to start with the procedural history. This will fill you in on a lot if you don't know the story. Okay, this is where it gets important. On February 9th, 1999, the body of Hae Min Lee was discovered buried in Lincoln Park in Baltimore City. Her ex-boyfriend, Adnan Syed, was eventually charged with first-degree murder. The state's key witness at this was a guy named Jay Wilds, who testified that Syed confessed to him he had murdered Miss Lee, and then he helped Syed in burying the body in Lincoln Park. So that's how they start this. Oh, it's Hae Min? I thought it was Hae Min. Hae Min. Okay, Hae Min. Sorry. If you guys have never seen the Serial podcast, their first season was about Adnan Syed's case. The state also introduced into records at the time, which they showed that his cell phone received an incoming call around the time that Jay Wilds testified he and Mr. Syed were burying Lee's body. And this call registered with the cell tower, which is the strongest cell site for the location of her body near Leakin Park. They also found his palm print on the back of a map book found inside her car. Now, guys, yes, for those of you who are millennials and stuff, we used to have maps, and they used to put them in cars because you didn't have a phone. The map showing the Leakin Park had been removed from the MacBook, and the torn-out piece was found under the rear seat of her car. In 2000, he was convicted of first-degree murder, kidnapping, robbery, and false imprisonment. He was given a life sentence plus 30 years. All right. So we're not going to worry about this part. The appellate court obviously supported it, and he was confirmed. In 2010, he had filed a petition for post-conviction relief. And they went along with it. There were some issues there. And things happened from there. So the post-conviction court initially denied his petition, and then he filed for an application to leave for appeal, which the appellate court granted. The Court of Appeals granted his request for a remand to consider a newly obtained affidavit from an alibi witness. And then the post-conviction court granted him a new trial. The state then filed for an application to leave for appeal, and he filed a cross application for leave to appeal, both of which were granted. In 2018, so this is how long this takes, guys. Post-conviction relief in the criminal setting is a long battle. Post-conviction relief is not easy. It will take years, sometimes decades. Look how long it took Adnan Syed, 20 years to get this rolling. It takes a long time to get stuff sorted out. A long time. Patty Cakes, you're saying, is this the court doco where he's set free in 2022? This is the most recent ruling from the Supreme Court of Maryland from like 2 days ago. That's what we're talking about. So he's still out as a free man, but we're going to keep talking about it. But I think I can answer your question. So in 2018, the appellate court granted the new trial. Okay, after granting the state's petition for writ of certiorari, this court reversed the judgment of the appellate court and held that Syed was not entitled to a new trial. So the state, after they lost the appellate court, went to the Supreme Court. The Supreme Court said, nope, he doesn't get a new trial in 2019. So at that point, you're like, well, I guess you're fucked. And here's the interesting thing, guys. This part right here, this doesn't happen for like 1% of the people who do post-conviction relief. This is extraordinarily rare. This much stuff happened. So there was a motion to vacate his convictions. In 2021, Erica Suter, his new counsel, approached the state's attorney's office about pursuing a Juvenile Restoration Act motion on behalf of him. And the discussions led them to conduct a joint investigation concerning the integrity of the convictions. And as part of that, in March 2022, the state and Syed filed a joint petition for post-conviction DNA testing of Lee's clothing using procedures that were unavailable at the time of Syed's trial. And the interesting thing is, guys, even his cell phone data, think about it. How much of cell phones changed since 1999? And DNA has changed much since 1999. So in addition, and we covered this back in 2022 when he got initially released. So this has been an ongoing battle for him. In May of 2022, the state's attorneys requested his trial file from the Maryland Attorney General's office. In the course of reviewing it, They discovered what she believed exculpatory information in the form of two handwritten notes that detailed two separate interviews. And according to the state's attorney, these interviews included information concerning two suspects other than Syed who had possible motive to harm Hae Min. So she informed his attorney of the documents, and those copies were not in the defense file. And there's nothing in the defense files that resembled any of that. And how would she know? Because the defense file has probably been jealously guarded by attorneys and had like handed off when somebody else takes over. They went through every scrap of paper. It's like shop every scrap of paper. I'm looking for Colonel Girdwood. So in September of 2022, they informed Hae Min's brother, Young Lee, that the state would be filing a motion to vacate his convictions. So the prosecutor was aware that Lee lived in California. In a telephone conversation on the 13th, Feldman reviewed the motion with Mr. Lee and told him there would be a hearing on the motion to vacate. She also provided her contact information to Lee. Feldman followed up with Lee via email on the afternoon of the 13th. And she said, attached to the draft on the motion we are likely filing tomorrow. And the motion covers the information we uncovered about alternative suspects. I'm happy to share with you the status of the investigation as we move forward. If you have any questions, please don't hesitate to reach out to me. And then he says later that day, we disagree with your course of action and stand against the motion to vacate judgment. We believe that there is overwhelming evidence and the court convicted the right person. I hope you understand the emotional turbulence this trial is causing us. It seems there is never an end to it, but we understand your position as an attorney to do due diligence and cover all possibilities. Now, I will say, chat, the way he responded to that is grace. That's very graceful. I'm sure he had to sit down and think about that a couple of times. But I have, as a prosecutor, I've had to talk to victims. And when you tell them, like, hey, look, we're going to do something here and you're not going to like it, it can devastate them. I remember when I was an intern, I was in law school, I was a student, I was a law student, I was an intern in a prosecutor's office. And we went in to speak with the victims of a case. And it was a case I had done a lot of work on. I had listened to, at the time, when I was an intern, they're like, hey, you want to listen to some jail calls? And I'm like, oh my God, this is great. In hindsight, you look back at it now and you're like, they suckered me into doing something they didn't want to do because it's a bunch of white trash talking about how they're going to be how they fuck each other. But we went in and talked to the family about how we can't pursue murder charges against this guy, but we're going to offer him manslaughter and he's going to accept it. And he only faces up to 20 years in prison instead of life. And they were very unhappy with that, but there was nothing we could do. That was the reality of the situation. And that if we tried for murder, we would lose. And, I got to see how the prosecutors talked to them, and it was very, 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 very tough. But they did it, and you learned a lot. But I've also had meetings where the victims are just like, they lose their fucking minds. So it totally makes sense. But this guy was graceful. He says, we understand you're doing your thing, but we don't agree with it at all. All right. So on September 14th, she replied by email. She said, I very much understand your family's position. I'm so sorry for the pain this is causing you. And she promised to keep them updated with all new developments. So they filed the motion on September 14th. In the motion, they asserted that they had received new information after the entry of his judgment of conviction that calls into question the integrity of the conviction. And the state, therefore, was proceeding under the penal code. And specifically, they had uncovered Brady violations and new information concerning the possible involvement of two suspects. And once again, we come down here and chat. In Brady v. Maryland, Supreme Court held the suppression of by the prosecution of evidence favorable to an accused, which is exculpatory, upon request violates due process where the evidence is material either to guilt or to punishment, irrespective of the good or bad faith of the prosecution. So they admit there was a Brady violation. Additionally, the parties identified significant reliability issues regarding the most critical pieces of evidence at trial. With respect to the alternate suspects, they point out that there's 2 alternative suspects. In the state's reinvestigation, new information was learned about these individuals that suggests motive and or propensity to commit this crime. And they said, however, in order to protect the integrity of the ongoing investigation, the names of the suspects, which suspect in particular, and the specific details will not be provided at this time. They said that they located a document in the state's trial file which provided details about one of the suspects. A person provided that information to the state that one of the suspects had a motive to kill the victim, and that suspect had threatened to kill the victim in the presence of another individual. The suspect said he would make Hae Min Lee disappear. He would kill her. That's pretty strong as far as an allegation goes. The state located a separate document in the trial file in which a different person relayed information that could be viewed as motive for that same suspect. So multiple people are pointing out this guy could have done it, this other guy. The information about the threat and motives of harm could have provided a basis for the defense to present or bolster a plausible alternative theory of the trial. And due to the ongoing investigation, we can't give any more information. They point out, though, the information about alternative suspect would have been helpful to the defense because it would have helped substantiate the alternative suspect defense that was consistent with their strategy at trial. Now, we don't know exactly what they pled at trial, but it looks like the prosecutors here know, hey, they were trying to do this at trial. You guys are being crazy. So we're going to keep going here. She further recited that in 2022, through investigation of property records and other media, the location where her car was found was known to one of the alternative suspects, and that a person related to family owned a house near that location for many years, and that person lived there in 1999. Dun, dun, dun! In addition, according to the motion, the defense located formally documented evidence unavailable at the time of the trial that one of the suspects had, without provocation or excuse, attacked a woman unknown to him while she was in her vehicle. Sounds like we're pointing out there's other defendants here. The state further recited this incident occurred after Syed's trial and that the suspect was convicted of this offense. And they further state the parties had obtained credible information when the suspects had engaged in multiple instances of rape and sexual assault of compromised or vulnerable victims in a systematic, deliberate, and premeditated way, meaning as a serial rapist. The suspect was convicted of this offense, which also occurred after Syed's trial. They also find out one of the suspects had engaged in aggressive or violent acts towards a woman known to him and forcibly confined her. And he also made threats against the life of that person. And according to the motion, these events happened prior to the trial in this case, and this information was known to the state. That's a big deal. And they say, given the circumstances of Hae Min's death, this evidence would have been consequential to the defendant's theory of the case. You're goddamn right it would have. The motion also recounted the police had improperly cleared one of the suspects in the course of the initial investigation as a result of errors in administering and interpreting polygraphs. Well, polygraphs are freaking voodoo anyway, so of course they messed that up. The motion also pointed discrepancies between Wild's statements to the police and his trial testimony. And they expressed concerns about the reliability of the incoming cell phone records upon which the state had relied at trial. Yes, remember, cell phone records from 1999. How good do you think those were then? Something to think about. The motion made clear the state's attorney was not then asserting that Syed was innocent, but rather it no longer had confidence in the integrity of the convictions, and Syed at a minimum should be afforded a new trial. So he then joined the state's attorney's request for relief. Obviously, he's going to say, I agree with everything they said. They're not going to say anything else. So they had a September 16th hearing in the court's chambers. So on Friday, September 16th, the court held an off-the-record, in-camera hearing in the court's chambers. We've had this before with Young Thug, but notice, the prosecutor and defense attorney were present. Now, here's an issue. Mr. Lee received no notice of the in-camera hearing and consequently did not request to attend it. At the in-camera hearing, the prosecutor and defense provided the court with copies of the two documents the state's attorney's office believed contained Brady material, neither of which was included with the vacater motion or otherwise placed in the record. Remember, they said that because we don't want to tip our hand on going after the real bad guys. The record indicates the date and time for an in-court hearing was the following Monday, September 19th at 2 p.m., which was set during this hearing. The prosecutor then communicated with Mr. Lee at 1:59 on Friday, saying, hey, you've got to be here Monday morning. Bye. Nope, that's not going to work. So she says the court scheduled an in-person hearing on Monday at 2 p.m. It's in person, but I asked for the court for permission you and your family to watch the proceedings virtually if you would like. So if you'd like to watch, the link is below. Please let me know if anybody in your family will be joining the link, so I will make sure the court lets you into the virtual courtroom. Now, Lee did not respond to this email because Feldman did not receive a reply from Lee. She texted him at 1:22 on the afternoon before the hearing, which is Sunday. Just wanted to make sure you got my email about the hearing schedule for tomorrow. I sent a video link in case you wanted to watch. So he then said, yes, I got the link. I'll be joining you. And then on Sunday, later that night, Mr. Lee retained counsel in connection with the vacater motion. On Monday, his attorneys entered their appearances in the case. At the same time, Lee, through counsel, filed a motion for postponement and demand for rights. In his motion, Lee requested the hearing be postponed 7 days to allow him and his family to travel to Baltimore from the residence of California. And he said, based on the potentially dispositive nature of this hearing and the right of victims and surviving families to meaningfully participate in such proceedings, the family wishes to be present at the in-person hearing. The notice provided was patently insufficient to permit that to happen. Lee also said that even if he and his family had been able to attend that day in person, they cannot meaningfully participate and be heard because the prosecutor hadn't disclosed the factual basis supporting the vacater motion and because the motion did not name any suspects. What are they going to do? What are they allowed to do? That's the issue here. Well, we want to meaningfully participate and do what? What are you going to do? We don't like this. Well, you're not going to like anything that's going to happen. You want that guy to sit in prison. Newsflash, he's not. So what are you going to do? Sit there and go, that's not true for 4 hours straight? Like, this is nonsense. So they have the hearing on September 19th. And the court conducted the in-court hearing on the motion, and members of his family and members of the press attended the hearing in person, as did Mr. Lee's counsel, Steve Kelly. Mr. Lee did not attend the hearing in person, which that's fine. I've represented people at these hearings before. You show up for them. Yeah, though the court was called to order because you're their representative. The court asked Ms. Feldman to state specifically what notice the state gave to the victim's family in this case. And she said, after explaining that counsel and I met with the court on Friday, the hearing was scheduled for today. Prosecutor advised her communications to Lee by email and text on the preceding Friday and Sunday. She also explained she had provided Lee with a copy of the motion prior to filing. And the court said, well, and asked about it. And, as far as your understanding from the family, the attendance was going to be done how? And she said, so I did not know until he texted me back yesterday whether he was going to attend via Zoom, and he indicated he would. Had he not indicated to me he wished to travel here to be here today. The court then asked Lee if he was on Zoom, and hearing no response, the court then heard from his attorney. Which, you gotta fucking be there, man. You gotta be there if you want to be there. If you want to be there to talk to shit, you gotta be there to do it. And it sounds like Mr. Lee wasn't there. He's like, "Hello, much disgraceful." And Lee's attorney asserted that the notice given to Lee on Friday afternoon was patently unreasonable, and it is. 2 days notice for a hearing. It provided no opportunity for him to be present. And there was a lack of meaningful participation in the proceeding. They also complained the state failing to give notice of what had caused the concern. And they also just once again point out we wanted 7-day postponement so Lee could attend the hearing. And the court responded with, look, we do electronic stuff every day, and we do it here every day. I was told Lee lived in California and he'd be present by Zoom. Now it appears since Friday, Lee has changed his mind, and he wishes to be present here in Baltimore. The court also stated it saw no basis in the statutes and rules Mr. Lee had cited in his motion to conclude the victim's family would have a right to be heard. And they said, however, the court immediately continued. Now, of course, if Mr. Lee was present on Zoom and he wanted to speak, I would allow him to speak. Well, and that is a big deal. You don't even show up on Zoom. That does make you look like a fucking dickhead. And then the judge says, or his attorney says, well, if you suspended for 7 days, he would be here. And the court says, wait a minute. Are you not aware that him, by telling us on Friday he was going to appear by Zoom, is why we set the hearing today? Because had we known that on Friday, of course, we would have scheduled this hearing to when he was planning on arriving within a reasonable amount of time. So we didn't do that. I think the court's doing a little bit of a fib there, or he doesn't recall the timeline properly, because they didn't contact him until afterwards. Kelly responded that Lee did not state on Friday any time he would participate. Kelly acknowledged that in a text to the prosecutor at 4:08, he said he would participate in by Zoom, but Kelly continued that was shortly before he retained the attorney to represent him. And the attorney observed that Mr. Lee is not a lawyer and he has every right to be counseled by an attorney as to his rights and then act accordingly. And the judge says, do you see the confusion? Mr. Lee told the state through text that he would participate by Zoom. Now, counsel and I have been in close communication about this case procedurally since February. So had he told Ms. Feldman he didn't want to participate via Zoom, he wanted to be in person, she would have communicated that to me, and then we would have taken the appropriate steps. And then once again, he says, the attorney says they didn't receive adequate notice under Maryland law. The court says, well, actually, it just says it has to be notice. It doesn't say how long. It doesn't have anything about reasonable notice, which that right there, that's a problem. Like, it doesn't say reasonable notice. If you're going to read a statute, I think there's a bit of reasonableness presumably interpreted and injected into everything written down. There's, it says reasonableness, But does that mean by their logic, if it doesn't say reasonable, well, you could do whatever the fuck you want because it doesn't say reasonable? I mean, come on, Judge. I don't buy that for a second. I don't buy that for a second. That is a bit of an issue here. You'd have to argue the notice is reasonable. It has to be reasonable. And then his attorney, and yes, his attorney responded the way I would have too. Reasonableness is a standard that's been long applied by the Supreme Court in everything. And that's true. We do reasonableness for everything. There's a presumption of reasonableness. And yes, 1 day notice is not adequate. They also pointed out under certain laws, he had a right to speak at the hearing. The circuit court disagreed and said it has nothing to do with sentencing or disposition hearings. That's not what we're doing. This is a different hearing. So the court denied the motion for postponement, but allowed Kelly time to have Mr. Lee join the hearing by Zoom. Mr. Kelly then called Mr. Lee, following which he reported to the court that Mr. Lee was at work, but would just request 30 minutes to get home in a private place where he can participate. The court granted that accommodation and recessed the hearing. The proceedings resumed 50 minutes later. At that time, the court said to Lee, who was watching the proceedings by Zoom, "You're here today to make a statement. The court is ready to hear from you." And he then said, "I've been living with this for 20 plus years, and every day when I think it's over, it always comes back. And it's not just me and killing my mother. And it's really tough. Just going through this again and again and again and again. It's a nightmare over and over again." He said he believed the state had done a fine job of prosecuting Mr. Syed, and that always he thought the state was on his side, but he now felt betrayed. Well, there's some issues with the truth, man. We have to do the right thing. Further, he stated he was not against an investigation. Well, yeah, as long as it leads back to where they're already at. But the vacator motion was really tough for him to swallow. Gagged on a little bit. Lee noted he had wanted to make his statement in person, but didn't know he had the opportunity. And after Lee finished speaking, the court said it's mindful how difficult this day is for you. And appreciated Mr. Lee joining Zoom to make the statement because it's important to hear from the victim or the victim's representative. But why? What did we get out of that? So after that, the attorney requested permission to just say a couple of sentences. The court declined the request. And they said they believe they satisfied all the requirements on the criminal procedure rules, and therefore the hearing will commence now. The court then heard from the prosecutor, and she said, "What is unusual in this case, unlike all the other motions to vacate my office is filed, is that this motion should be granted. We will be continuing our investigation, and we will not be asking the court to dismiss the case at this time. Instead, we are requesting that trial be set." And they said the state's ultimate decision to proceed with a new trial or ultimately dismiss is contingent upon the results of the ongoing investigation. However, the state is requesting the defendant could be released on his own recognizance pending the investigation should the court grant this motion. So she did not go into the alleged Brady material that was provided during the in-camera. And after the brief remarks, the court then read the text of an order granting the motion. He said, "At this time, we'll remove the shackles from Mr. Syed, please." And after a pause to allow the unshackling to occur, the court continued and said, at this point, everybody knows the press is going to be out there. He directed a person who was present in the courtroom to apply the ankle monitor to Adnan Syed for the purpose of electronic monitoring. So from then he got uncuffed and they put an ankle monitor on him. And the court entered a written order, and it said, upon consideration of the papers, in-camera review of evidence, proceedings, and oral arguments of counsel made on the record, the court finds the state had proven grounds for vacating the judgment and the conviction on the matter of Adnan Syed. Specifically, the state has proven there was a Brady violation. Additionally, the state discovered that new evidence that could not have been discovered by due diligence in time for a new trial and creates a substantial or significant probability the result would have been different. The order stated Syed was to be released on his own recognizance and placed on home detention with GPS monitoring. And the state shall schedule a date for a new trial or enter the nolle prosequi within 30 days. And nolle prosequi means just a dismissal. So on September 28th, Lee noted an order to appeal. And he also filed a motion in the appellate court to stay proceedings presenting the appeal. So that's what happened there. On October 11th, after the DNA testing yielded a mixed profile from which Syed was excluded as a contributor, that's kind of a big deal. He's not on her fucking clothes. Wow. The state's attorney entered a nolle prosequi, or as they say in the courtrooms, nollied of the charges. So it's done. At this point, dismissed, dropped. Bam. So on October 12th, the court denied Lee's motion to stay and ordered to show cause why the appeal should not be dismissed. The parties filed responses, and the appellate court ordered the appeal would proceed. So initially, it vacated the vacator order and reinstated the convictions and ordered for remand a new hearing. The panel first held that he was obtaining a ruling regarding whether his rights were violated. And they stated this action is conflicting with, and yeah, this is funny because they point out this action conflicts with the state's interest in procuring justice. Really, it does? Because to ensure the constitutional rights of crime victims are honored and protected. Yes, they should be protected, but not at the sake of a defendant. And they say the state of Maryland has given constitutional and statutory rights to victims, and the state's attorney should not be allowed to thwart those rights in the way that happened here. The nolle entered under the circumstances violated the right to be treated with dignity and respect. Because the nolle was void, it was a nullity and therefore does not render this appeal moot. If it's a nullity, it means it never happened, so they're pretending it didn't happen. They're disregarding it. But yes, remember the dignity and respect of victims. What about the defendant's rights? Well, those matter too. But how much? But how much? But how much? That's the issue. That's the problem. That's the problem. I say, do I support the woke DA? No. But the defendant's rights are paramount. If the prosecutor takes a case and he goes up and looks at it and says, there ain't shit here, I want to dismiss it. That's where it ends. The victims might get mad and say, wait. It doesn't matter what they say. They're not the ones doing it. They may not like that result. Fine, put your input in. Bitch, moan, and cry. This is wrong. I don't like it. That's where it should end. That's the only input they should have. If the prosecution is going to dismiss charges, so fucking be it. Maybe they're right. Maybe they're wrong. Maybe they're being woke. Maybe they're being political. Who really knows? Either way, they are dismissing charges. That's the end of the game. And that's the problem here. It was the end of the game. Game over. So, fuck his rights, tell her dad. Fine. Fuck your rights. His rights are more important. That's how it goes. The defendant's rights are more important than victims' rights. They should always be important. The Sixth Amendment über alles. Fifth Amendment über alles. Fourth Amendment über alles. Victims' rights, they can go brush up horse shit off the sidewalk for all I care. I mean, because what we're gonna go through it like we're reinstating this guy's conviction because someone's feeling got hot. On the merits, they held the circuit court erred in finding Lee received sufficient notice. Okay, fine. I guess we have to rehab the hearing. The majority concluded here the notice here in email 1 business day before the hearing, and that's fair because it's 1 day before, technically business days, was not efficient to allow Lee, who lived in California, to attend the hearing. Next, they held his right to attend the hearing was violated because he was functionally required to attend remotely. And then they found that his attendance via Zoom satisfied his right because he was there. And they said finally they held that he did not have a right to be heard at the vacator hearing. Well, that's where we get to what happens. And then this gets to the Supreme Court here. Okay. So the Supreme Court of Maryland the state of Maryland was represented by the Attorney General's office there. And they filed a response recommending we grant both petitions, which they did. Because remember, hold on, we're on page 29. Remember, it's not the state of Maryland here. It's Syed versus Young Lee. It's defendant versus victim. It's not the state right now. The state of Maryland's just like you may as well hear it. We're going to stay out of it for now. It's libertarian bullshit. Well, no. Whose rights are more important right there? Whose rights should we be protecting? I mean, whose rights are more important? Does the victim's rights? Like, does, a defendant's trying to put a defense together? But for example, here, you know what? We'll do an example. Okay. So, here we go. Ohio Constitution. The Ohio Constitution, Bill of Rights. Here we go. Question for you. For example, here. Proceedings free from reasonable delay and a prompt conclusion of the case. As a victim, you have that right in Ohio. I have a client. We're trying to put together a case. Whose rights trump there? My client's right to have a trial? My right to help my client build a reasonable defense? Or the victim who says, this is taking too long. I don't want it too long. Who's right? Who takes over? Whose rights control? I mean, there's problems with this. Like, how does this work? To upon request to confer with the attorney for the government, okay, and to be heard, to be heard in any public proceeding, okay, to be heard. But what does that mean? Because their opinion doesn't matter. It shouldn't, should it? How much should it matter with? Like I said, that's the problem here. How much power do they get? That's where you have to come up with an answer. Kimbo says, I don't know who's more American. Well, So we're going to keep going. Just something to think about. Between the two petitions, they agreed to review the following questions. Did the entry of the nollie prosequi moot the appeal? Does the victim have a right to be heard at a vacator hearing? Does the victim have the right to attend a hearing in person, or does remote attendance satisfy? Did he receive sufficient notice? And must the victim who seeks reversal of the court order due to violations of the rights make a showing of prejudice? And if so, did Mr. Lee make that in the case? So those are the issues that they are dealing with. So they get to the standard review, guys, and look, this is page 34 of 187. We are not reading all 187 pages. We're not going all night, chat. We're not going all night. Real quick, Cedar Rose saying, you met her for 12 months, saying, thank you, Cedar Rose, saying, 1 year, baby. Where's my gift, Sean? Sean? And then Philip Cogan says for $5, if you want to trigger actual Justice Warrior, why would I want to trigger him? He's a fellow Sean. There's not enough Seans in this world. Say this guy was innocent. I don't know if he was innocent. I don't know if the state's got enough evidence to convict him, really. I think that's an issue. Catherine says, I sent you an email unrelated to this current topic. Well, thank you. Thank you. What are you guys saying here? Stacy, when Sean Freeze, I had to check to make sure I'd actually paused the feed. I just stopped figuring he's muted or dead or just being retarded. I love you very much, Mon Chéri. He's not innocent. Fuck evidence. Well, if we're fucking evidence, he probably, by definition, he would be innocent. So, oh, we're gonna keep going though, guys. Sorry, you can't see the thing here. 187 pages. We're not reviewing all of them. We're gonna chuckle. We're gonna chug along here. So they go through the mootness issues. They address those. The bigger issues are, I think, about getting to whether or not they're, and this is a massive opinion. I mean, they talk about mootness, guys, and I read this earlier. That's actually interesting to me, getting to like the minutia of law. And I think, while he was appealing, I think the ability for them to nolly that was paralyzed. So I think it was a nullity. I would agree. I would agree with that, but that makes sense. But we need to move on to the other issues. And those are, does the victim have a right to be heard at a hearing? And they say that a crime victim has a right to be heard at a vacator hearing. And they reach that conclusion based on the unambiguous language of Article 47 of the Declaration of Rights. And I think that's what they call their Constitution, which is kind of based. That's kind of a base way to name their Constitution. Shinny says, you're missing all that stuff. I understand. It's a discussion about the mootness issue. And it's really boring otherwise. Like, I read through it, and I don't think, like, it's not the important issues here about the ultimate issue, whether or not he had the right to attend. It was just whether or not he had the right to keep pursuing the appeal. And as much as I, want to talk about it, it's like, I thought it was really good, but it's not going to work for everybody else. Trying to be nice. It's like 20 pages of it's nonsense. They have the right to, upon request, if practical, to be notified to attend and be heard at a criminal justice proceeding as these rights are implemented, and the terms crime and justice proceeding and victim are specified by law. And they say that victims have the right to address the court under oath before the imposition of sentence or other disposition. And disposition is a resolution to a case. So Vacating a sentence would be a disposition, and at a hearing which the alteration of a sentence is considered. And they also say there's a cross reference that says for the right of a victim or victim's representative to address the court during a sentencing or disposition hearing. And they say, as they explain in more, there is a right to be heard. So you have the right to be heard in a meaningful way, which includes the right to be heard on the merits of the parties in support of the motion or against the motion. So they go through all of this and they talk about the issues that go through. How do you determine? And what's the construction of the statute? And I did read this part, but I skipped a lot of this part because I'm not a Maryland attorney, so I don't care how state of Maryland constructs statutes and reviews that. I really wanted to get to the victims' rights issues because I think that's something I actually, would need as a practitioner. How does the court handle that issue? Because they keep going, and it's interesting what they do here. They talk about like Oberfell, and yes, the case about gay marriage. And they talk about how they want to get there. I mean, they just keep going, chat. This part here becomes a massive slog that even I was not wanting to get involved in. And like, we're only at part 2. Gays can marry. Yes. Thanks, Obama. Anyways, they said the circuit court permitted Mr. Lee to address the court before the court started the hearing, but Lee did not have the benefit of hearing the parties' presentations in support of the motion before he addressed the court. In addition, the attorney's request to say something else was denied. And they point out that Hae Min's brother had a right not to speak generally, but has the right to specifically address the evidence. Obviously, Adnan disagrees. And they say, we agree with the respondents, and that's Hae Min's brother. The victim's right to be heard at the vacator hearing includes the right to address the merits of the motion after the prosecutor and defense have made their presentations. After hearing the evidence adduced at the hearing, if the victim believes the state met its burden of proof under the code, the victim must have the right to explain why the victim believes that to be the case and ask the court to deny the motion. If it's happened here, the victim is only permitted to speak. The victim does not have the opportunity to fully address the merits of the motion. This undermines the ability of the victim to have a meaningful input in the court's decision-making process. Well, and I don't understand why they think they have any input. They get to say yes or no. Like, we like it or don't like it. It doesn't matter, though, what you like or don't like. That's irrelevant. And they say that these rights are only meaningful if they're afforded before a trial court formally binds itself to a particular disposition. And they say, having gone through the process that led to the conviction, which can involve years of stressful proceedings, which it very well can, in this case probably did, a victim should not be forced to stand silent concerning what the victim believes to be flaws in the prosecutor's evidentiary submission or the legal correctness of a vacator motion. They said such a scenario would not treat the victim with the dignity, respect, and sensitivity that Article 47 of their state constitution requires. I think it does. You got to deal with it. If the victim is represented by counsel, the court must permit counsel to address the merits of the motion following the parties' presentations, if counsel wishes to do so. And they say to that end, the judge presiding at the hearing where a victim is represented by counsel should typically inquire whether the victim's attorney, or both the victim and victim's attorney wish to be heard. And I have spoken for parties. I've been hired to go out and do one of these. And you get hired and they tell, like, okay, what do you want me to say? And they give me like a handwritten note and you read it. They say when the victim has a potential legal issue to raise before the court, and especially when the issue is complex, the assistance of victim's counsel could be critical in vindicating the victim's rights to be heard meaningfully. In addition, where the prosecutor and defendant both seek a vacator, the victim's attorney can help the court just as the adversarial process aids the court in virtually every other court proceeding. And they say because the parties here were not in an adversarial posture. Well, of course they're not. They both agree. Neither the state nor Syed was well positioned to present a contrary position to assist the court in analyzing the issue. It doesn't matter. It doesn't matter. The prosecutor says, we're done. That's what matters. Was the court going to say, no, the victim convinced me, we're going to keep the conviction alive? No. The two parties involved said, no, we're done. That's what matters. Fanny. Oh my gosh. Some of you guys are just like crazy out there. Well, he actually didn't have tears. He's a psycho. Kent Madison says, it's any different than a victim's family speaking at a parole hearing since the question is, I'm not a law person. Oh, sorry. I was read a little too literally. Ron Burgundy, that. I mean, you have the right to be heard, but generally speaking, if they say, I don't want this person out, the parole board's generally not going to change their mind and go, well, you convinced us. Bam. You're not getting out anymore. So, no, I'd say they shouldn't be able to do this. Donate more subscriptions so J-Rock can find a wife. Yes, chat. Remember, keep it a gray-free neighborhood, chat. Keep it a gray-free neighborhood. Fatty Caddy is saying for $5. Sean, does this mean Kayla has the right to demand Aaron give her the real fuck she deserves whenever she wants? No comment. No comment. Oh. That's the same says it's different. It's after sentencing, not part of a charging decision. I understand, but I think at that point, though, at a parole hearing, if the parole board's going to let someone out, even if the victims don't want him out, that's not going to change their idea. And it shouldn't have a bearing like that. The victim should not be allowed to override. Because if the court or a parole board was going to deny a hearing when the victim agreed, does that mean they automatically get to override the judge? I mean, the victim's not an uber party here who gets to do whatever they want and can change, the world's issues on a whim. Also, I got your email today. Holy shit, that is crazy to see, by the way. They shouldn't be able to overthrow a conviction over equity and lie stories. The DNA didn't match, and they have concerns about other potential suspects that were never provided. Is that a lie? No. So, anyways, we're going to keep going here. And they say, in this case, Mr. Lee was not afforded the opportunity personally or through his attorney to address the merits of the motion following the parties' presentations in support of the motion. For these reasons, this was error. In addition, it was error for the circuit court to conduct an off-the-record in-camera hearing at which the court reviewed evidence in support of the motion, evidence the parties did not introduce at a subsequent hearing in open court. They said, thus, even if he had been permitted to speak, Mr. Lee would not have been able to address the complete evidentiary submission. They say, going forward, barring unusual circumstances that are not present here, such as a victim's representative being a suspect. Well, how would that? Okay, so you're saying there are some limitations. The court should ensure that a victim is able to respond to all evidence upon which the parties chose to rely in seeking a vacator of a conviction. They say a victim doesn't have the right to call witnesses or present evidence. Now, this is where it sounds like the Mr. Lee got over his skis a little bit. They argue the victim has the right to participate as a party, including cross-examining witnesses and calling witnesses of their own. God, that would be a shit show and a half. Everybody disagreed with them that they have full participatory rights at the hearing, and we agree. And that's, yes, thank God they didn't have to, like, be all retarded about that. But yes, that would be awful. They said, indeed, it would be problematic to permit victims to participate in the hearing as a party because doing so would directly contradict Maryland law, which is clear on the issue. And they say a victim is not a party to a criminal or juvenile proceeding, which it shouldn't be. It should not be. Pausing, but the state screwed up and let a killer out. Well, that's what happens if they screw up. People walk free. Oopsie poopsie. Then you hold the state accountable and say, don't screw up. So they talk about his right to attend the vacator hearing. And they claim he had the right to attend the hearing. And they said, as discussed above, the victim has a right to be heard. And because hearing in this case was held in person, we hold he had the right to attend the hearing in person. The one-week continuance prevented him from receiving the reasonable opportunity to attend in person, and therefore result in a violation of the right to attend the hearing. So they keep going and they talk about all this, and they're just like, look, you have the right to be there and you have the right to speak, but you are not a party to this. And I deal with the fact, like, well, I want to present my own evidence. Like, no, you're not doing that. We're not going to let you do that. Obviously, they talk about the reasonable notice. He had no notice here, chat. That is one thing I will give him the benefit of. He got no notice. He got not even he barely got 24 hours notice technically. And why I say that, because of business days. You don't there are times where, like, for appeals and statute of limitations, things like that, you count calendar days. But outside of that, for things that the court says, business days or court days, that means Monday to Friday, excluding holidays. And they say notice in this case was not reasonable. He got notice on Friday, and it was deficient because it didn't give him time to make arrangements to travel across country. The notice was deficient because it failed to state the location of the hearing, other than describing it as in person, and implied the only option was to observe the hearing remotely. Well, the location of the hearing is in Baltimore at the courthouse. Where do you think they're having it? Altoona, Pennsylvania? This is ridiculous. And they said the notice wasn't reasonable. And as they keep going on this chat, they talk that the failure to provide him a notice and the chance to be ready is not fair. It was not proper. So because of that, their proceedings on remand. And they conclude the appropriate course of action is to remand this case to the Circuit Court for Baltimore City for further proceedings consistent with his opinion before a different judge. On remand, the Circuit Court will begin where they were immediately after the state's attorney filed the motion to vacate on the 14th. If a new hearing is scheduled, Mr. Lee must be given reasonable notice to the new hearing date to allow him to attend the hearing in person. See, it would be fucking hilarious if he's like, nope, I'll just appear by video now. That would be the best. That'd be some Lawler captor shit. That would be amazing. He's like, nope, don't worry. I'll just do Zoom. And him and his counsel can address the merits of the hearing and the merits of the parties' presentations and all the other um and all of the matters that are relevant to the circuit court's disposition of the vacator motion. So he's gonna be allowed to hear it. And what they do is they go all the way back to the start of all this. But what does that mean? Well, remember, he's not released. He's out on bond. So could they order a new trial? Sure. Could they order a vacator? Sure. Let's say they don't. He can end up going back to prison. Theoretically. I don't think it's going to happen at all. He's not going to be sent back, and nor should he. Gail says it's taken this long to do all this. Yeah. Well, think about it here. Hold on. This thing here. Well, they talk about the appeals. Like, there was a massive amount of time here. Where? Hold on. I don't know. I guess we can do it here. Like, so you have the trial right here, and then you have like the branches off of it. Things that were challenged, and then those things were challenged, and that was challenged, and then you have, the issues with like it. I'm trying to draw this in a way it makes sense, but you have all these competing things that are going on, and there's different like branches to this all at once. This makes a case very difficult when you have all these issues going on at once. So like you have this going along here. Okay, well, at the same time, you have a break off and that branch goes this way. Okay, well, that you need to appeal again because you lost. And this one here, there's a break off, but it keeps going along normally. And everything keeps going normal. Okay, well, this all takes time for itself to get healed up. And this one's here, but then it gets sent back. And then it has to come back through. I mean, there's a million different ways this can go where it just... It takes a long time. It takes a long time to get this far. And remember what I said, post-conviction relief is not a quick thing. It is not it's not the young man's game. It's a lot of hurrying up and waiting. So let me see here. So this is from here. This is... So yeah, we're gonna get here. Sorry guys, we had to get to this part. So they say in an effort to remedy what they perceive to be an injustice, the prosecutor's circuit court worked an injustice against Mr. Lee by failing to treat him with respect, dignity, and sensitivity, in particular, violating his rights as a crime victim's representative to reasonable notice of the vacator hearing. Yes, but remember, this injustice is far bigger than this injustice. When you have to put them on a scale, there's no way those balance. I don't see that. What are you guys saying? You guys talking about Turtle Boy? Do you also wonder why Sean lied about DNA witnesses and cops? When did I lie about DNA witnesses and cops? I'm going off what the court citing here as the reasons. Oh, wait, two of the guilty people Sean supported? Two of the guilty people Sean supported. Which ones? Chad is saying we want Clyde. I'll work on that. Clyde, come here. You lied and said the DNA didn't match. All right, hold on here. Where is it? Wait, I need to. Damn it. Yes. Okay, here we go. The DNA after testing of items in Lee's clothing yielded a profile mix, which he was excluded from as a contributor. If he's excluded from as a contributor, there you go. That means it's not his. Okay. So the stuff the state sent out came back. Up, he's not on it. So now we got a problem. Who the fuck is that guy? Who's that mixture? Remember, they're not saying he's not innocent, but they have questions. The state has questions about the integrity of this conviction. Once again, maybe he did it. I said that. Did he do it? Maybe. But this case is not strong enough to keep a man in prison. But they're saying there are other contributors to a DNA mixture found on her body. We should figure out who the fuck those are first. And it sounds like there's a lot of people we need to sort out first before we put someone in prison. So that's why we're on here and see if we can. Okay. All right. Proceedings on remand, the conclusion. So the entry of the nollie did not moot his appeal because we are able to provide an effective remedy for the violation of his rights as the crime victim's representative without violating Syed's constitutional right to be free from double jeopardy. You know, they say that, but they're the ones who didn't get their ass clapped on a leg monitor and get jerked around for the past 2 years and possibly go back to fucking prison over this. They can talk a big game, but this doesn't mean shit to me. The remedy is to reinstate the convictions and remand the case for the proceedings relating to the vacator motion consistent with this opinion. Those proceedings will go before a different judge. And that's because the judge got things wrong there. And they talk about a respectful and sensitive way to proceed would be for Lee's attorney to be consulted about potential dates for a new hearing before the hearing is scheduled. We expect the parties and Mr. Lee on remand to work together in good faith to ensure that all subsequent proceedings occur in a timely manner. And they say, although the effect of the opinion is to confirm the reinstatement of the convictions pending further proceedings, they are not ordering any change to Syed's conditions of release. Remember, he could still go back to prison. He can still go back to prison. And that shame says if you can't comprehend that our system fully contemplates and intends and yes, it accepts the problem that guilty men will walk free. Yeah, that's part of the game. Yes, as Omar Little says, the warrior poet of Baltimore himself. Blessed be unto him. It's all in the game, baby. It's all in the game. They also point out, consistent with this remand, Mr. Lee shall be afforded a reasonable notice of the hearing, that is, notice sufficient to provide him with a reasonable opportunity to attend such hearing in person. Cool. He's going to go through all of this, and then he's going to go through all of this, say, oh my God, this is so bad. And the court's going to say, cool, don't fucking care, you're done. And then what's he going to do? Like, literally, he went through all of this. He's going to go through all of this for the court to say, cool, don't fucking care. Vacating granted. That's what's going to happen. That's what's going to happen. Like, seriously, I demand to have a right to be heard. Cool. And here's what happens. Vacated. Bye, Mr. Syed. Have a great day. You went through all this just to sit there and get they're literally asking the court, we have a right to be felted at the end of the day. That's the problem here. That's the problem here. They say at a new hearing, Mr. Lears or his counsel should be permitted the opportunity to be heard on the merits of the hearing and motion after hearing the entirety of the parties' presentations in support of the motion. And that's it. And they say judgment of the appellate court of Maryland affirmed in part and reversed in part. Case remanded to the court with which the direction to remand the case to the circuit court for the Baltimore. And see, that's how it has to go. Remember, guys, that's Supreme Court. So the Supreme Court's telling the Court of Appeals, hey, tell the circuit court they got to redo this. And then the circuit court or the Court of Appeals is going to go, hey, circuit court, trial court, you need to fix it. Here's how you're fixing it. So it's like a game of tell, as somebody might say, as somebody might say, an insular game of telephone is what this guy's going to turn out to be. J-Rock says, kind of sounds like this guy got screwed. Did he really get screwed? Did he really get screwed? Did he really get screwed? Yes. Your Honor, Nick Ricciardi told me I could jizz on a corpse. Yes, maybe there was a deal to testify against Marlo Stansfield. Yes. Earl Ward says, any of you total morons sucking off Muslims have no fucking experience with them or are Muslim. Oh, Assalamu alaikum. I don't know. Like, seriously, though, it's, homie, these are your fucking rights, too. I'm more worried about what this does for me. I have a selfish self-interest in this stuff. So there are, and the funny thing is, there's almost the equal amount of dissent from these guys. And they have a dissent that's been filed. And they point out that, and he says, respectfully, I dissent. In some, the majority expends much ink to posit the following. That the Nolly did not moot it. That they have the right to attend the hearings in person. And the victim or victim's representative has a right to reasonable notice. He says, I will outline my positions below. And which judge is this here? It is dissenting opinion by Judge Houghton or Houghton. It's like Hotttogo. Hotten. It doesn't work that well. Like the song goes. "20 years is more than enough time served. He's guilty." No. I have no problem with life sentences. Sometimes people don't deserve to be let out. Like, whoever murdered and buried her shouldn't be out of prison. They should not be out of prison. Yes. Yes, aloha snack bar. Takfir! Takfir! Aloha lakbar! No, I am not a tack fairy. Don't worry, chat. Anyways, he attacks these issues and he talks about the mootness. But I mean, guys, this is, like I said, 100 pages of dissent, which is massive because usually you don't have exactly. I mean, I will say this is a lot of malding and seething. This is a lot of malding and seething to. This is a lot of malding and seething to respond by saying, "No, you're wrong." It's like, Jesus Christ, you guys. This judge is really fired up. And there's a lot of statutory interpretation and construction that the dissent spends a lot of time arguing about. So that's where you kind of get these at times. I argue, I dissent, but for some different reasons here. And they say, accordingly, I dissent. And he says, really, the biggest issue is the circuit court is not statutorily required to hear from a victim or victim's representative because those proceedings no longer concern punishing the criminal. Rather, these proceedings concern the very basis of the defendant's guilt or conviction. And I think it's funny that the way they do it here, the other justices have authorized me to state they join in this dissent. It's like, there must have been some problem in Maryland before where the judge is like, no, I didn't sign that. No. So they have to get approval. And then there's another dissent. And this is the way they do this, where everything's like tabbed over to the side, is so weird. That must be like a leftover from the days where you'd fold papers in half or something, because I don't get why they do this. This is so, oof. It's not aesthetically pleasing. So what's going to happen here? We don't know. But he is still. Oh, a Sega Dreamcast saying yes, our court is weird. Mm-hmm. So he is still on bond, and theoretically he could go back to prison. Which I think is a crazy notion right now. Although, would they order it? I don't think so. I don't think that would happen at this point. But yes, he could potentially be sent back to prison after he's been out and he's had all this time in the world. And imagine that if you were told, hey, you just got released from prison, but there's a good chance you're going to be stuck there. You've been released, but you're going back. And imagine having that hang. Like, I don't know if this guy's been handling himself in the meantime, but yeah, this is not good. I just don't see how this works. I don't see how this works. I mean, like, let's say that happened. Like, how would you be able to function every day? Think about that. Every single day you're out there, you've been released. You're out there in the world, thinking in the back of your head, there's a possibility you're going back to prison forever. That would fucking drive me crazy so bad. Nero saying, yeah, right, he'll never see prison again. Leftists and their libertine friends make sure the guilty and criminals get every chance to be free. Well, I think I have a concern about that, but I think ultimately he won't, but there's no way that guy doesn't close his eyes every night and go, I might go back to prison. Oh no. Like, that would keep me up at fucking night. I'd be like, every night would be horrible. WBM Entertainment is saying, I hope he can go back. I hope he goes back, but I get the legal way to do it. All right, so we got some other questions to get out here. WBM is saying Adnan definitely killed that woman because Jay knew where the car was. So either Jay killed Hae or Hae Min, or Adnan and Jay did it together. That's a compelling argument. A very compelling argument. Kia Patrick says, I still keep a Rand McNally Road Atlas under my driver's seat. I'm a boomer. Brad says, yep, now maps go on the wall. Yes, they do. Amateur Iconoclast still has a Road Atlas in his car. I need to get paper maps back in my car again. Never a bad thing to have. And then Ariel says, I listened to jail calls yesterday where people were naming their drug dealers. Lol. Yeah, that happens too. Are you interning somewhere? Because yes, people, when they're on the fucking phone, all they do is just fucking snitch themselves out. It's crazy. And Fatty says for $2, what if the victim wants them inside him? Oh! No, actually, you got to do it like dice. What if the victim wants them inside him? Oh! Hickory dickory dock. And then Fatty Caddy again says, so Kayla has a right to be bent over the felt. Oh! Oh. Yes, the Tattletale machine, guys. Yes. Shredder says, do Arabs talk to themselves in Arabic or do they hear their thoughts in English, kind of like subtitles? Oh. The real answer is they're guided by Allah. Inshallah. Inshallah. J-Rock saying, go to a country without extradition. The problem is a lot of countries that don't have extradition in the United States are not places you want to live. Generally speaking, the places with extradition treaties aren't too bad to live in. I mean, the ones that don't have them kind of fucking suck. So you might not want to do that because you're going to go to shitty places you don't want to go. So I would never recommend that. I would never, ever recommend that. To Sam Kinison now. Yeah. They trick white ladies into freeing them. No, that's what pit bulls do at the pound. They trick white ladies into freeing them. Nero saying, other than the shitty places, the others are places most criminals can't afford to live in. Well, sure, but still problems. Go home, Syed. Go get those rights. Yeah. Pities can be sweet, but they aren't very smart. Yes, they are, but sometimes they're like an IED that licks its own balls, so it's a little scary. Let's see here. The Vatican is nice. Hang out there. Okay. Adnan Sneed. Yes. Oh. Pause saying, good show, Sean. I do hate your take, not you. Well, I appreciate that. We can always get along. The park rangers were on Love to Eat Puss 79. That's a new name. Thanks for being here. I can't believe there's 78 other people who decide to tell the world here on YouTube they love to eat puss that much, but I'm not here to judge. The park rangers on Joe Rogan saying gangsters used to hide out in Yellowstone to avoid arrest. Well, yeah, back in the day I could see things happening. But remember, back in the day, Yellowstone, well, I mean, it is now still, but you go back 100 years, Yellowstone was a fucking no man's land. It was the wilderness. So yeah, you had to go hide out in the middle of nowhere. So once again, guys, it's going to come back down to these two. Adnan Syed and Hae Min Lee. And what's going to happen? Is he going to get released? Or are they going to, is the judge going to deny to instate the vacator? Because let's say the judge denies it. He denies to vacate the motion. What happens then? Do we just release him and say you're released, time served, because it's not fair to put you back in jail? What do we do? What do we do with this guy? What do we do with him? Because he's been out for like 2 years now. I mean, you have problems. Maddie B says as a part of Yellowstone is not part of a state, so you can't be charged with crimes there. You could still be charged with a crime. There are ways around that issue. I know people have read it, but it's not a free zone. One of January 6th guys got assignment in Belarus. Not bad. Well, yeah, except you're living in fucking Belarus. And the minute they're angry at you or you piss them off, guess what happens? They're going to take you to the border to Poland to go boop, right across the border to the EU, and guess what happens? Your ass is coming back. So, got to be careful what you want. J-Rock says he's been out for 2 years and hasn't gone to ground. He says, sounds innocent. Yeah. Otto says, go to a native reservation to hide. The problem is, like, when you're on the res and you're not part of the res, they know you're not part of the res and they know you're there. It's really hard to hide on those if they don't know you. Yeah, Belarus is not a nice place to live. It's not. I will say the Belarusian MREs, though, are pretty good. I had one of those. Fun fact, when 2.0 and I started dating, and we were together first, we started getting together, you know, we were like, you're stuck at home. There was nowhere to go. It was 2020. So we started watching shows, and then I'm like, I was watching a Steve MRE video, and she's like, what's that? And we put it on the TV, and we were watching, and she's like, oh, that seems kind of cool. So we ordered like MREs and had like little dinner dates with MREs, and we try them. Now she didn't like a lot of the Russian one and the Belarusian one had like very basic things like buckwheat porridge and like pork or beef. She didn't like those. She doesn't like pate. I will say though, like Russian MREs have like really, really, really good pate. Like, mwah. I will say that's like one of the things Slavs do really good is pate. I love pate. But, you know, you could try all the different kinds that Steve was trying, and we didn't get the French one. We were like, that would have been fun to do the ostrich, but we didn't get to it. So, yes, she thought it was cat food, she did like some of them, but she thought a bunch of them were basically cat food. So, yes. So let's get this down on a tray. Nice. Fatty Kitty says that's wholesome. Well, it was a lot of fun. We had a lot of fun. There wasn't a whole lot we could do. I remember after a while, finally, like, we could go out once, and we we're like, oh, this is neat. But it was really sucked for a while. The French one's probably good. Yeah, a couple of them were decent. And Joe Lloyd says, how romantic. Well, it was. It was kind of a neat way. Like, we were like, it was fun. We had, you know, yeah, it worked. It was great. I wooed her over. I wooed her over with Russian shortbread crackers. Buckwheat porridge. Are they still eating like fucking Stalin is in? Yes. Yes. The Russians aren't very much better. They eat a very basic meal. So he says, how does she know what cat food tastes like? She had a lot of cats at one point. So I'm betting she was a crazy cat lady at one point. So fair and balanced. That's the cutest thing I've ever heard. Well, yes, the Italian MREs are amazing. Yes. Where they, Yes, with their cordials in them. You can get a little alcohol. Any nice hisses? No. No, because we wouldn't try those. Jerax says explains why you're fat now. Massive calories like 3,500 per day, eating 3 a day. Yeah, thank you, J Rock. That's exactly what we were doing. Oh my god. I know if I like pate, just get Braunschweiger from Aldi. Yes, I understand that, but I'm just saying, like the pate in them was phenomenal. Yes, check out that hiss. Yes, either we had Emery dinner dates or we burned trash in the front yard. Oh. Did you guys do HEMA afterwards? No, she doesn't do. She doesn't play. She doesn't sword fight. No. Do I believe in aliens? Sure. The Canadian ones are referred to as lungs in a bag. Yes. I call her Mon Chéri. I call her a lot of things, but yes. Or she calls me God damn it, get over here. Actually had a kid. Like I went to high school with. He was in the home ec class and he hadn't been in there yet. And when the home ec teacher yelled at him, he started fake crying. And she said, God damn it to him. And he said, well, I was a little kid. I thought my name was God damn it, get over here for the first 2 years. It's like he trolled the shit out of her. Oh. This is said, speaking of sword fighting, what's up, Nick Aaron? No, we're not going to get into that tonight. We're not doing that tonight, chat. Just Joy says, listen, fucker, is what I call my husband. Yes. Did you see the guy that attacked the judge in court was back in court today for the trial? I didn't see that until way late in the afternoon. But yeah, it makes sense though. He's out in Las Vegas, so everything's like 3 hours behind. We might actually watch that coming up too. That'll be a cool one to watch. We're going to catch up on it. So Super Wiener says answer to most slurs. Oh, there you go. That's not bad too. Fatty Kenny says, I had sound effects as well yell when yelling about our wife. I'm glad you had sound effects. Good. I hope that increases your audio engineering prowess. I hope it does. Scarebro says, how much boot leather must God, I fucking have this rule of reading everything. How much boot leather must Nick be putting in his tongue to silence on Aaron? I mean, if what Ralph said is true today, quite a bit. Yes, the prosecutor for Baltimore County, former one, Marilyn Mosby, is on house arrest for fraud. Yes. Yes. Barnes can't defend that guy because he's in his hometown and he's scared of the government. Just Joy says, what did Ralph say now? Ralph has made a claim and he says he's got proof of it. And so far, I mean, he's, he went and called the court and got the link for court. So I don't know, Ralph is plugged in with obviously one side of this equation that April has pressed domestic violence charges against Aaron, which, given the fact it's like at minimum would be 4 months old if it happened like when she got kicked out of the house, is at minimum 4 months old, if not older. Really fucking weak. So Sunseal is saying, does anybody know what the hell's going on with Tim Pool, Lawrence Southern, and Tenet Media? Yes, Tenet Media was funded by Russians who used sanction money that got around sanctions to um, influence U.S. politics and political discourse. Therefore, they violated FARA, the Foreign Agent Registration Act. And it just happens that Tim Pool and Lawrence Southern were paid for that. Well, Winter Soldier says Danny On is covering it. Yeah, I'm going to cover it tomorrow. There's a lot to it, and I want to make sure I read through everything because there's a lot going on there. It's very, very it's very interesting. I wonder though, what's the exposure for people like Tim Pool or Benny Johnson or Matt Christensen? Because they're claiming they didn't know. Fine. But there's also other people like Lauren Southern. She's Canadian. Who lad is she fucked? I don't know. I don't know what Canada's laws are. Are they even worse than FARA? You know, given the fact that obviously it's a shittier government and laws up there, is she going to get sucked up by the government? Is Lauren Chen, the roaming millennial, she's a Canadian. She also holds citizenship in Hong Kong. Is she going to get fucking indicted up there or wrapped up there? Or is she going to get indicted down here as a conspirator? There's, FAR is no joke, guys. So we'll see. We will see. Those Russians were funded by the CIA. Yeah. Dimful has always been a plant. Yeah, I know. I saw the clip of him where he's like, Ukraine is the enemy. It's like, okay, they're not an enemy. We shouldn't be wasting our fucking weapons there, but they're not an enemy. The whole holes are not going to destroy America. The whole holes are not a big threat. The whole holy are not they are not the danger that's laying out in the woods. They don't go bump in the night. A Sega Dreamcast says it's the indictment against their parent company. None of these people are accused of wrongdoing yet. Remember, that may change. There might be more things to do. Although I probably at this point they're safe, but they should still be getting an attorney. Lauren Southern, though, she might have run afoul of Canadian laws. It's not just American laws she's got to worry about. She's got to worry about Canadian laws where she lives. She lives in Canada. Poole claims he just licensed his show to Tenet. Well, we'll see. RT is banned in Canada. Yep, and they were RT people. So, and the people running it were from RT, and that's how they got around stuff. Jackie of Almost All Trades says, can I cover the Shuley Network executive producer being caught with 6,000 images of cheese pizza? No, I understand the Dabbleverse has got some stuff going on there that needs to be called out, but if they won't address their own house matters, I'm not jumping into that pool. As much as it's funny it is, that's not where I really want to go. That's not where I want to take this place. And I appreciate it. I really do, Jackie. I mean, Nick's got his issues, and sure, people are mad. They think I'm A-logging him hard, whatever. Well, it's all in the game. But no, I don't necessarily need to make this a hunt to find every person on YouTube who's fucking things up. So, but thank you for the super chat. Bobka says, I looked at pate and it looks so disgusting. Oh my God. I don't know how you can say that. Dave Rubin, or I'm sorry, Kale Brick says Dave Rubin too. Yes. Yeah, Dave Rubin's here. Those Russians are CIA nibbas. Yes. They very well could be. Kim and I says Tim Pool's downfall was putting on the red beanie like Sargon said he would. Yeah, I think that was Tim Pool's. The grift was good for a while for Tim. Oh, he ate good. But yeah, I think that was his ultimate issue too. But unlike a lot of people, I think Tim's actually saved his money. So he'll probably be all right. Tim Pool is suing the Harris campaign, and 2 days later, this happens. Yeah, but this has been going on for a while. Right, the investigation had been going, so I don't think it's that. Yes, Tim Pool has predicted the American Civil War like 500,000 times. Krassenstein wants to uncheck the back room. That's so funny. Huh. Are we going to talk about crypto scams that kind of fell over? Yeah, Tim did outlive his usefulness. I think so too. He's kind of run his track. I think it was Jeremy and other people said you could track people like when they hit their stride, it's like a 5-year window, and then it falls off. And and once you hit your stride, you have 5 years. Your shot. You have 5 years to shoot your shot. And you got to be ready for it when it happens. Scarebro says, imagine having a press manager like Ralph, quite the deal, paying pesos on the dollar. Very affordable when you have 3 ongoing court cases. Oof. Oof. Medicare is always right. Jim is always right. Kimbo says, did I enjoy my time being covered in the Dabbleverse? I know WATP was covering me being a retard for a minute, but other than that, I don't really know wherever else I got to, but sure. I mean, they're like, oh, well, he sucks. Like, cool. It's like nothing new that I don't know. Yes, mom's spaghetti and knees weak. Mom's sketty. Does cocaine speed up that 5-year timeline? Yes. 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 The cocaine allows your timeline to go from here to here. I don't know. Some people make it 5 years. Yeah, some people don't, but it's once you hit your stride, you have like a 5-year window. So, but yeah, guys, getting back to this is where it's going to come down to Anand Syed and Hae Min Lee. It'll be very interesting to see how this sorts out. Yeah. I didn't get to get back to that, but it is the issue. It's this tension, the victim's rights and the defendant's rights. And you would think the defendant's rights can, they're going to face off and, it just, chomp and eats. But in this situation, apparently in the Maryland Supreme Court, they're equals. They can both eat each other. And you're just like, wait, how does that work? How does that work? So, Fatty Caddy's saying, Aaron's massive wee-wee is practically a weapon. Thankfully, Kayla's body was completely wrecked that it fit perfectly. Poor April still can't walk right. Jeez. Oh. Melton on Nobody Likes Onion was using my coverage too. Okay. Hopefully it was good. I don't know. But yeah, I mean, people will use it either for information or to laugh or to mock. That's kind of how it goes. $5 Sucky Sucky says, I do not have Twitter. You're missing out. You're missing out, bro. I refuse to twatter. Well, Kaz says lol. Well, there you go. I'm glad you're saying lol. Colostomy Bag says, I just can't stand Tim Pool. Literally the most annoying person. I would rather unironically listen to Sean Hannity. Whoa, you're a brave man. You're like, wow. It's like The Simpsons where the girls are like, I'm so hungry I could eat at Denny's. Like, I would rather listen to Sean Hannity than Tim Pool. I would not, if I had to choose, I'll listen to Tim Pool. Like, if you told me, like, the trolley's on the tracks and my options are Tim Pool or Sean Hannity, I'm going to be very torn up and try to figure out, is there a way I could derail the train and it kills both of them? But if I can't derail the train in time and do that, God, that's a tempting thing. I'd be pulling the lever for Sean Hannity every day. Just, you're a great American. Gone. I'm 5'6". I don't have a stride. You're right. I do not. Tomorrow's Darrell Brooks' final appearance is sentencing. Yes, in Milwaukee. Yep. I'll cover that tomorrow night. And if you guys are new, we do a show every Thursday night at 9:30. Cover all kinds of stuff going on. There are a lot of big things to talk about. Some interesting things. We're going to talk about what happened out in Canton here in Ohio, where the cop basically like Supermans into a kid, gives him the flying knee. The updates with going on with former President Trump. Also some stuff in his campaign. Like they're fighting Isaac Hayes' estate. One of the doctors in Matthew Perry's death has pled out and is agreeing to testify. The Nashville shooters' True Manifesto was released by the local newspaper, and you can read it. And holy shit, it's crazy. Chase Bank. If you guys saw on TikTok, various members of certain communities were out there trying to basically, with an unlimited overdraft, withdraw like 30, 40 grand and then freak out when the bank turns around and locks it down the next day. Sean Kingston's facing fraud charges. And then, yes, we're going to be talking about the tenant media thing tomorrow. We're going to go through that indictment. It's very interesting. It will be probably one of the bigger things to talk about tomorrow because it is massive in scale about what's going on and how things are being dealt with. So, like I said, it's tomorrow night at 9:30. We got a lot to talk about there, guys. Be there or be square. What about Delphi? Yes, I was thinking about doing a separate show on that, but if it's really just the one big motion, yes. Richard Allen and Delphi, literally, he just got told today by Judge Gull, you have no right to present a case. You have no right to present a defense. Have fun in prison, stalker child. That's literally what Judge Gull said. So, it's really bad. It's really bad. And we're going to take a look at it. Yeah, but we have a bunch of things to talk about tomorrow. Also, Twitter was banned in Brazil. Sarah Boone's continuance got denied. Yes, it did. Yes, it did. No, we have not covered Sarah Boone's interviews yet. No, we will. We will. We'll cover that tomorrow night. He gave some interviews to the press. State says no right to present a defense. Well, basically, you can't offer any defense or third-party involvement based on Odinism or any of the previous other suspects the police may or may not have interviewed. So basically, there is no alternative theories they can offer in trial. Boone's lawyer said he's gonna pay her over time. Yeah, we'll see. That's not gonna happen. That's not happening, chat. That's not happening at all. That's not happening. Let's be real. Let's be real. Let's be real. Let's be honest. So I'm going on vacation for a bit. Well, have fun, Brandon. Enjoy yourself. Hopefully you're going somewhere fun. May you may your drinks stay full and cold wherever it is you're going. And you're probably sitting there thinking like, I'm going to a Mormon vacation, so there's no alcohol. It's like, oh, well, whoops. JRX says, I'm surprised the ninth lawyer lasted a week. I think Sarah realizes it's too late. Brandon says, which means my dog's going to jail. Show us some Clyde and I'll slide you that coin. You know what? I thought I called for Clyde earlier, and I don't know if he came in here. Clyde! Clyde, come here, Bubba. Come here. I hear click-clacks. I hear click-clacks. Do you guys hear the click-clacks? Come here, buddy. Hi. Oh, you look so tired. Come on, Bub. Hi. Oh, yes. Mwah. Hi, Bubba. You don't smell like pee still. You're doing such a good job about not rolling in the pee spots in the yard. I am so proud of you. You need to keep this up, buddy. Keep it a streak. Keep it like forever. Oh. He just wants to go to bed. It's okay, Bubba. You can lay down. Come on. It's okay. It's okay. There you go. Oh, he wants to go night-night. Oh, he was sleeping, Chad. I'm sorry. He was being sleepy, boy. He's already got his eyes closed again. It's like, little do you know, I'm going to have to drop you down in like a minute or two. So. He had to go to the vet for his checkup. He is 22 pounds. Right? You said 22? Okay, 22 pounds. And Laney is 20. He's finally back to a healthy weight. After a year and a half. Took him a while, chat, but he's good now. He was all skin and bones when we first got him. He was so skinny, you could see his back. All right, Bubba, I'm going to put you down. Oh, you've got food in your hair. Mwah. Mwah. Okay, buddy. Yes. Boone's lawyer says he had lots of clients that pay $50 a month. I mean, sometimes I could see that working out, but it's like they, yeah. Consider receive conjugal visits. I don't know. Maybe. Apparently, the lawyer's getting his mates to help her with the case. Cool. Clyde demands Italian MREs, yes. Yes. The lawyer hinted at getting her police interview suppressed, or at least parts of it. Well, there is a big thing that apparently came out, chat, and we'll go through this real quick. There's a part of Sarah Boone's interview that had never been released, apparently. Where allegedly, I think it's a new thing where she's like trying to say it wasn't intentional and it wasn't intentional. And as they're like leading her out in cuffs, and she's like, it's not intentional. I didn't mean to do it. I didn't mean to do it. Wasn't intentional. It's like, whoa, that's not good. That's not good. Yeah, he was worn out. He had a new bull peen to chew on. That's another thing, guys. You want to keep Clyde rolling in the bull peens he can chew forever. Help him out. Cedar Rose says he's a little sausage. Yeah, but like I said, when we got him, he was very skinny. You could see his spine, and he had kennel cough. So compared to where he's at now, it's better. A lot better. Yes, free Sunny. What's that? Oh, yes, she got him 12 pounds of bull peens. How much is a bull peen? Actually, surprisingly a lot. You'd think that like nobody would buy those, or like that's not a high in demand item. But I guess the drying, and because they take them and dry them and like braid them together, that's actually apparently like a skill set or something, because they're surprisingly expensive. Kale says there was a body found in my suitcase. The body found in a suitcase not far from my house. Yeah, it's like $15 a pound. Yes. Yeah, they're surprisingly expensive. Stacy says braided cocks. Yes. Bull penises. They take them and they braid them together, and it's like a chew toy for dogs, and they can eat them. and it's better than rawhide. It doesn't, because rawhide can hurt dogs, and then synthetic rawhide's even worse because that can shred the lining and that can shred the intestinal tract on dogs. But bull peens are a good source for them to chew, and they can chew it up and eat it. It's really organic for them. The problem is with bull peens, they make these little toys where you can like ratchet down the end of it on there. So because the dogs will chew it, and then the problem is when you get to the end, dogs would like swallow it because it's the last little bit, and they choke on it and die. So they make like a little yeah, hold on here. Yeah, they're called bully sticks ultimately, but yeah, here are here are bull peens, and then they make these, and I'm not joking, these are real fucking things. I have a feeling it's going to turn into the next fucking Baldo chat if I show it. But anyways, this is what bull peens are. Dried up bull penises, dehydrated, and they get braided up. And then to make sure, because dogs will chew it, but when they get to the end, they might eat the whole last bit. So they make toys that you can use where, like, this one can roll around on the floor, or other things that basically act as a stop so they don't eat the last bit and choke on it. Not to now says, opening the stream to see a bull cock. Yes. Distances, I hate that you can see the cross section. Yeah. They stink too. No, they don't. They're actually not bad. They're not bad. But yes, that's so they can eat them and it doesn't hurt them. Because if they don't, that last little bit there, if they were to eat that, they could choke on it because, as they're chewing their way down, they get to the last little bit that's like right here, and there's not anything for them to hold on to or gnaw on, so they'll swallow it and they die. So what you do is you shove it in here, and this is threaded right here, and you just twist it and it locks it down. So, yeah. They sell dried trachea and ears too. Yes, pig's ears are really good. Pig's ears, those get all greasy and leave like mess everywhere. I don't like pig ears unless you have like a dog outside. Then let them eat pig ears all day long. I've never done tracheas before. Those would be good. So Clyde eats a bag of dicks. Yes, he does, apparently. Yes, when you put it like that, yes, he eats a bag of dicks. Quite a bit. Matt says literally it's a Baldo. Well, kind of. Fire and Ice says, I have an old school Cleveland Indians can. Yes, I do. Yes, I do. I does. Got Chief Wahoo. Still like the Guardian. Still like the Indians. Hella says you sniff them? Well, no, but you could. They're sitting out in the house on the floor. You don't smell them. Yes, they're turning the frickin' dogs gay. Yes, it's a bulldo. Ha! There we go. It's a bulldo chat. Oh. It's a cut cage for doggos. The Baldo also keeps you from choking on cock. Yeah, but is the Baldo a choking hazard? That would be the danger there. Why am I, as a lawyer, sniffing bull wiener? I'm not sniffing the wiener. Yeah, Joseph says the whole bag, bro. Yes, I hate it when you go, because she says it like, Clyde, where's your peen? Or she'll go, Clyde, it's new peen day, yay! And I'm like, oh my God, it's so bad. And she says it even a higher voice than that. It's like that white women voice they use with their animals. And you're just like, no, don't. Don't. Yes, there's a vast difference between a rawhide and a bull penis. You get the golf clap. Oh my god. Oh my god. They're not bad. I didn't. Branded Boldo will sell. Yes. Jirac says, was today new peen day? I think so. But the thing is, he can eat like one of these over the course of a day. Like, if you give him one, he will just sit there and fucking go to town on it. Hmm. If the Baldo becomes a choking hazard, I may want to watch that ER visit. Oh. Indians forever. My parents are from the Cleveland area. I wonder if you represent any of my cousins. Maybe. I'm over on the east side of everything, so that'll help. If your family's on the west side, no. Over 26 grams of peen, yes. Oh my god. Does Clyde give it the hawk tour? Oh no. Oh no. Adam Watson saying though, did you see that Kerry Morrissey is trying to get back on the case for Alec Baldwin? Yes, I saw that. I've not had a chance to read it. Johan for $20. Thank you. Saying for some Asian bull peen. Why would I want him on the little ones? Because he might choke on those. Fatty Caddy says Kayla's buy bull peens, and that drives up the prices. No. No, 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 no. Not nice. The Joe Loy for £10 sterling. The King Sterling says snacks for Laney and Clyde. LOL. OL. Well, that's the funny part because Clyde will eat them and he'll chow down on one. And we have like 3 of them out because obviously we're trying not to have them fight. But like he will, if he's chewing on one and like one of the cats walks by, and I'm talking about like there's like 5 feet between them. Clyde like gets up and's like he gets all protective over the bull peen, and he's snapped at Laney before about it. It's kind of hilarious because everything's quiet, then all of a sudden Clyde just freaks out like it's a Vietnam flashback. But like, you will not touch my bull peen, and he just loses his mind. And we're just completely sitting there like, wait, what? What the hell happened? Um, Stop this madness. I can send you a link for non-dick dog treats. Yes. Tiberius Magnus saying, I thought Baldwin's case was finished. It is, but Kerry Morrissey's very much engaged in the time old, as a tale as old as time, Copenhagen. That's the issue. It's just all the copes. And Carrie's like, no, judge, please don't. Now, I don't understand why she's doing it, though. It's almost, it's over 45 days late. I don't think the case is going to get reopened. She's trying again, and it's not going to work. She fucked up, and she won't take the L. She won't take her L and go home. Is Wednesday new peen day? Well, not necessarily. It's not meant like that alone is new peen day, but unrelated but never too early to plan for, $400,000 or 2 years of real estate ownership, and you too can file for Turkish citizenship, which has questionable extradition. Wait, why do I need 400 G's? Like, why can't I just own 2 pieces of property for 2 years? Why do I need $400,000? Jesus Christ. That's a lot. Wasn't Baldwin dismissed with prejudice? Yes. She's asking the court to reconsider, which it's not going to work. So, Skeeve Man. I know because he's up in Scotland. We are not going to say the king sterling, but it is £5 sterling for £5. So snacks for Clyde? No. Snacks for Sean? Yes. I like where this is going. Go get something. Go get some nice Sean snacks for the goodest boy with a gray beard. Aw. Maybe I will. I will do that. Nick Kreuzer says Copenhagen was found in 1167, Sean. Yes, it was. Does 2.0 saying, does Sean have a POB? What's a POB? POB. Oh, PO box. Yes. Yes. Hold on. I think it's down below. If it's not, let me check. I think I put it in there. If I didn't, let me know. Let me know. Let me know. Hold on here, chat. All right. Oh, by the way, guys, we passed 23,000 subscribers. So we're going to have to do a day. We're going to do a show about that coming up. Yes. The P.O. Box is down below. P.O. Box 716, Willoughby, Ohio 44096. Down in the description below if you open it up. She won't give her dogs a bunch of bags. She still has them. I may be able to send them. Yeah, sure. We'll take them. That's a big chunky dog. That's a big old honking dog. He's like, I'm too tired to move. He's like, too much food. That's how I feel some days. Okay, Fatty, I'm not reading that. Under Bidenomics, £5 like a bag of chips. Yeah, if I need $400,000 to buy off the Turkish officials, that's bullshit. They should be cheaper than that. It's not a fucking first world country. They should be happy if I give them $10,000. Unless you're talking like 400,000, like Turkish, blah, blah, blah. Like, then fine, I'll pay that. Nick Kreuzer is saying, keep for $10, keep being awesome, kid. Please don't spend this on penis. I will try. Yes, the Bonnie Prince is sterling. A whole rotisserie chicken is not a snack, Sean. Maybe to you. Yes, the penis orientation box. God. Okay, Fatty Caddy says, do you think Nick's obvious attack on Aaron could blow up be considered witness tampering or intimidation? Kayla was one thing, but April too. I mean, remember, Aaron has likely committed a crime with the whole revenge porn thing. I do think that's a legitimate issue. And remember what I said when I was covering this? It does, the idea that if a witness commits a crime, you pressing charges against them is somehow witness intimidation or witness tampering. That basically means even the police, because let's say you're a defense witness. If I'm a defense witness in a case, because you could tamper with any witness or intimidate any witness, that would almost mean I have an immunity from being charged with any process, like immunity from process at that point, that I could commit crimes and until things are over, the police can't stop me. And that's not the way that's meant to be done. If Aaron legitimately committed a crime, sure, fine. And I think there's a reason why they reported this on July 17th, and it took basically 45 days for them to figure out what they're doing. It took a lot of time because I think they were very careful about this because they were probably made aware of the other case And that was a lot of coordination going on there. Now, this thing with April, yes, the fact it's 4 months old, that just tells me it's bullshit. And yes, that definitely, I would consider that witness intimidation and witness tampering. Bella's saying, hey, can Poole and Benny sue Lauren Chen for what's happening to them? I mean, maybe misrepresentation of fact, um, fraudulent inducement. There could be certainly some arguments to be made there that if you would have told us and been honest that there were Russians running this, we wouldn't have fucking taken their money. Sure. I don't know though. I mean, like we're gonna have. I assume it's gonna happen, but probably not right away. But that's a very good question. Very good question there. Very good question, Bella. I think that could happen. Did I try the Italian MREs with the cordial liquor? No. The liqueur is not in, like, those get taken out all the time. No, we did not try the Italian ones. JRX says it's across many years and not decades. What? Oh, 400,000 Turkish lira. Lab. Okay, that's probably a little more doable. I was like 400,000 US dollars. For 400,000 US dollars, I better be like basically given like complete immunity to do whatever the fuck I want. Why won't you read Fatty Catty's super chat? Did he send it? I read it. I read it, you guys. Why are you guys like wigging out on me? I'm trying to catch up here. Can you sue Nick for welching on your 5K gifts? No. Fatty, you said you made a comment or two that I wasn't gonna read because I promised to read the super chats, but it was a non-super chat comment. I don't think that was a nice one. I didn't want to read it. I thought it was humorous though. Tim pulling question by AOC would be hilarious. Yeah, that will be. I'm sure it's gonna happen. I'd open a Jimmy John's in Istanbul before I sent you 400,000 lira, Sean. Oh. No, I wasn't talking about the super chat, guys. Sorry. Job well done says Gino seems to be resenting the cops talking to him. Yeah, I mean, well, most people like talking to the fucking police. You know what, Gino does not like being looked at like he's an informant. Nobody likes to be seen as being super grass. Chili DeCastro saying YouTube's trying to kill his channel. I mean, I haven't watched him in a while. I should see what he's up to now. Well, where are you guys? Let's see what you have here. I love how people hate Poole so much they suddenly the Democrat DOJ. Oh, I'm sure. Well, here's the thing, Distant. There is a ton of foreign money out there. Like, I think probably one of the biggest FARA violators right now is the whole Ukraine war. Like, all these personalities on Twitter and here on YouTube, especially the pro-Ukrainian shills, I guarantee, like, there are people who have been, like, even Runkle mentioned it. Like, the Ukrainian government or somebody affiliated with them or it's the organization was offering him money to shill shit for Ukraine and shill positive news for Ukraine in an effort to shape political pressure to make the populace here force the government to assist Ukraine more. Like, there's a lot of these guys. I guarantee you a lot of these guys shilling Ukraine are getting paid in a way they should be filing FARA, and I've checked a couple of them. They ain't fucking on FARA. I'm sure on the other side, there are people who are taking Russian money or Russian-directed money who are violating FARA too. But it's really the Ukrainian government shills that are violating the shit out of FARA. Happens a lot. A lot of people violate FARA. And there's a good portion of people, it's unintentional. So it's not just like I'm not surprised. I'm not surprised. Ultimately, hold on, chat. I gotta find my phone. I don't know where it's at. Oh, hold on, chat. I'll be right back. Kof Perun. Yeah, well, one of them. Yes. Although he's in Australia, so he's not really doing American policy. Really, I'd argue he's not he wouldn't have to far register. He's in Australia, but there are Americans who need to register and they haven't. So, guys, give me 1 second. I'll be right back. In the meantime, what are we gonna do here? Give you guys something to watch for a minute. Um, yeah, I don't know. Just give me 1 second, chat. We'll be right back. All right, hold on, guys. Brandon, thank you for that super chat. I appreciate it. Just I didn't have my phone sitting here. I left it out in the other room, and I'm like, oh shit, he might have sent something, but I don't have it with me. So, whoops. All right, well, that'll load up in a second here. The coup failed, chat. Well, yes, it will. Look at me. I'm the sandwich man now. Yes. Perron said that he was an Aussie. He sounds like an Aussie. I don't know. Sounds like one of you down there. He has a lot of information he gets. So that's a little okay. I'm not doing this in front of you guys because you guys could probably read my glasses. There we go. That way you can't read it. All right, hold on, chat. 1 second here. We're gonna do this. I don't want you guys reading it. Pinch and zoom. Yes. God bless the goal. All right, there is. Yes, $50 from Let's Go Brandon. Thank you, Brandon. I appreciate it, man. Thank you very, very much. I was ordering 3 calzones. No. DoorDash in 20 minutes. At this time of night, yeah, it'd probably take about 20 minutes. We can't read, Sean. We went to public schools. That's a scary thing. Me too. Yes, Hunter violated FARA as well. Yes, there are also a bunch of unregistered cutter lobbies, like the entire Heritage Foundation. Yep, a lot of people. A lot of people. A lot of people. A lot of people were taking money from the Qataris and the Emiratis. A lot of people are taking Gulf oil money. Perron makes hour-long PowerPoints about defense industrial stuff. Ukraine comes up a lot. He does a lot of Ukraine. He's he's not just pro-Ukraine. He's salami ukulele, I would argue. Ukraine without stain. I would love to see how his response to the Russians are just decimating Ukrainians right now, but I'm sure he was all geeking out about the Kursk offensive, and it's like, but what did it really get you? What did it really get you? You just wasted men. So, Lawler Scooty says ukulele. Okay, so the Ukrainians, it's like Slava Ukraini is like glory to Ukraine. Is like their battle cry. And they say it so much, it's just they're saying like salami Ukraine or salami ukulele. It's just more of joking about what they say because nobody cares. And see, here's the thing. I'm not pro-Russian. I just don't fucking want to be there. I don't care what a bunch of Slavs do in a mud hole. It doesn't affect us. We're giving away fucking weapons and equipment. And China's sitting there going, oh, yes, very interesting. These stupid Americans are wasting equipment and money. Oh, yes, maybe we take Taiwan now. As Alex Jones would do with his Chinese voice. Oh. So, that is why I have that feeling that I do. Scarecrow says, imagine the hypocrisy of your side piece filing a 4-month domestic violence complaint after reaching the peak of your career covering Depp v. Heard, siding with Depp. Well, I mean, there's, as I've said before, we're all hypocrites at some form or another at the end of the day. Make no mistake about it, we all are. It's just what are you being a hypocrite about? But we all have our hypocrisies. We have to. There's no way we can't. Your Chinese voice sounds like a bad Russian voice. Well, no, I have bad Russian accent as well. It's his premium accent. That was supposed to be a Chinese accent. Well, it's like Alex Jones when he does, oh yes, we put the poison in the water and the dog food to kill all your dogs. Yes. The literal vampire potbelly goblins are kind of running after us. Give me 1 ping for Shirley. 1 ping. I remember the one day when I got my hair done and I came in here and it was still all up. Somebody's like, you look like Captain Ramius. I was like, wow. We pay for that accent. Yes, you do. You had to hear that. I can work as a voice actor for Red Alert games. Yes. Do I have an Indian voice with an 8-point head bob? No. No, I'm not very good at that. DSP says, in China, they say, car very delicious. All right, guys. All right, that's it. We got to land the plane. Here, chat. Do a black accent. Shit. So, all right, guys. We're all done for the night. That's what I thought it was meant to be, cat, but I wasn't sure. I don't frequent 7-Elevens enough. We don't have too many 7-Elevens over here in my area. We have like a ton of Sheets now. Cedar Rose says, no, wait. Okay, what? What are we waiting for? Wait. What are we waiting on? When Alan, let's see, he's getting fucking violated hard this week. We're gonna cover that. In any case, I wish a good Rakita impressions. All you can do is Ralph and Mail. Your Ralph impressions are very good, man. So, okay, you wanted me to wait. What am I waiting on? Oh, no, I'm not going to play the Alex Jones song out. I got my own song to play out, too. Cece told me to wait, so I was waiting. Don't leave me, Dad. Okay, well, I'm going to get cigarettes. I'll be back, chat. I'll be back. I promise. Tomorrow we're going to get going, chat. I promise we'll be back. Before your song. No, we're going, checks. I'm going to go. I'm getting tired. I want to see if you wait. Well, I try to be nice. All right, guys. So we are going to go. Have a nice night, chat. Remember, tomorrow night, 9:30 Eastern, we are going to be live. And actually, we might, probably Friday, we're going to watch the Sarah Boone hearing. That should be pretty fun. It's like an hour long, and we'll watch the whole hearing as it went down and go from there. So have a good night, chat. Take care. And yeah, just because Adnan Syed may have done it doesn't mean he's guilty, especially if they vacate the conviction. So it actually may work for him. He may be able to actually do the thing, chat. 25 years in prison. So good night, everybody. Take care.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy?